Yes. As I said, I've got to do a half hour sometime with Phyllis Schlafly because she reminded me of things that I had forgotten. I mean, I talk about how the Article 3, Section 2 of the Constitution says, and I will read it to you just so that you have it right at the top of your head. In all the other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as the Congress shall make. So Congress can make exceptions. I've always focused on the regulations word. Phyllis Schlafly was just focusing on the exceptions word. Congress can establish exceptions to what the Supreme Court can rule on. And so Congress could pass a law tomorrow, at least in theory. Shane's laughing. Of course they would. Congress can pass a law tomorrow saying that the Supreme Court may not rule on issues that have to do with money and politics because the word money does not appear in the Constitution. And as Shane pointed out, the Supreme Court would strike it down as unconstitutional. And Congress then could say, we're going to ignore what the Supreme Court said. And as long as the president goes along with it, because he's the one charged with executing the laws, as long as the president ignores the Supreme Court, then, that's the way it goes. And in fact, that has happened in our history. Andrew Jackson displaced a whole bunch of Cherokees out of Georgia and drove them to Oklahoma and didn't drive them in a car, right? I mean, drove them literally at gunpoint, walking, and many of them died. And a representative for the Cherokees went before the United States Supreme Court, and this was in the 1820s, 1830s, whenever Andrew Jackson was president, first half of the 19th century, and argued before the court that this was unconstitutional to move these Native Americans from one state to another, or from a state to a territory. And the Supreme Court agreed with him. George Marshall was Chief Justice of the Supreme Court. Yes, that George Marshall, the guy who was Jefferson's second cousin, who Jefferson hated, the guy who ruled in Marbury v. Madison. And George Marshall ruled, you can't do that, President Jackson. And Andrew Jackson said, let George Marshall, words to the effect of, I don't remember the exact quote. Do you remember the exact quote, Shano? Okay, whatever the exact quote was, and probably somebody in our chat room will toss it out, or somebody on Twitter. But basically, what Andrew Jackson, President Jackson said was, George Marshall has made his decision. Let him enforce it. All right? In other words, he doesn't have an army. I do. And that was the point that back in Federalist, either 80, 81, 82, 83, or 84, it's one of the early 80s, that Alexander Hamilton made. That the Supreme Court was most likely going to be the least pernicious of the three branches of government because they had no power of the purse. Only Congress can appropriate money. And they had no power of the sword. Only the executive branch can run the army. The president is the commander-in-chief of the military. So the Supreme Court has no mechanism to enforce what they have to say. And as Phyllis Schlafly correctly pointed out just a few minutes ago on this program, and you will not find another person on earth whose politics are more different than mine. Well, maybe you will. I mean, maybe Karl Rove. I don't know. But, although, Karl Rove actually doesn't have any politics. Politics requires scruples. Phyllis Schlafly actually believes what she says. She is a scrupulous woman. I disagree with her totally, and she reminds me of my father. I disagree with her totally, and I have so much respect for her. And her point was that Congress can make in fact, the most important point she made about Dred Scott, when she pointed out what Lincoln said, was that, okay, the Supreme Court ruled that Mr. Sanford owned Mr. Scott. So what President Lincoln said was, the way that we should deal with this, the way that I'm going to respond to this, is to say to Mr. Scott, sorry, you poor SOB, Mr. Sanford owns you. But that doesn't mean that all the other slaves are owned by their masters. That just means that the Supreme Court ruled in this one case that this one guy is owned by this one slave owner. And Roger Taney, who was the Chief Justice of the U.S. Supreme Court, who ruled in Dred Scott and who wrote the decision and thought that he was going to put to bed forever the debate about slavery in America, when in fact he did the exact opposite. I mean, he initiated the Civil War. Thought that President Lincoln was going to say, oh, well, the Supreme Court has said that, slave owners have the right to own their slaves. So all those northern states that have outlawed slavery, they're going to have to un-outlaw slavery because I, Roger Taney, Chief Justice of the Supreme Court, I have spoken. And Abraham Lincoln said, screw that. Mr. Scott, Mr. Dred Scott, sorry, you're the property, Mr. Taney, but all the others, no. Here's an Emancipation Proclamation. I don't give a damn what the Chief Justice of the Supreme Court says. President Obama could do the same thing right now. He could say, okay, fine. The Supreme Court has ruled that Sean McCutcheon can make unlimited contributions. But that doesn't mean that David Koch can. He has the power to say that. Abraham Lincoln, his hero, said that. Come on, Obama. I know over at the White House you guys listen to this show. Somebody tell the president. Listen to Phyllis Schlafly about Abraham Lincoln.
You're listening to the Thom Hartmann Program. Call 866-987-THOM.
And tell him that Thom Hartmann sent you and told you that. Oh, man. We'll be back.